The U.S. Supreme Court on Monday rejected the appeal of First Lieutenant Michael Behenna, upholding his conviction for killing an Iraqi man he was questioning about terrorist activities. Joining me now from Washington is the Oklahoman's Chris Castile. Thank you so much for joining me, Chris.
Hey, you bet, Angie.
All right, well, did the Supreme Court give any reason for rejecting the appeal?
They did not, Angie, and they don't, typically say why they didn't accept a case. The whole issue here in Lieutenant Behenna's appeal was about the self-defense claim that he made in his court-martial. He was questioning this Iraqi terrorist about terrorist activities. Behenna was pointing a gun at the man, said that the man threw a piece of concrete at him and then lunged for his gun, and then Behenna shot him twice and killed him. The highest military appeals court said that Behenna really didn't have a right to claim self-defense given the fact that he was pointing a gun. The terrorist suspect was unarmed. Behenna was pointing a gun at the man while he was questioning him, so it really couldn't be a self-defense case. And that's the appeal that the Behenna legal team made to the Supreme Court. They asked him, look, soldiers in these kind of unconventional warfare situations are going to be pointing their guns a lot at people who may not be armed, because they don't know what's going to happen next. And ultimately, I think the court, you just have to speculate, that the court decided that this case really didn't have any broad ramifications beyond the Behenna case, that the specific facts of this case were what they were. The court-martial decided what they were going to decide, and that it really wasn't a danger. The decision about the self-defense claim really wasn't a danger to other troops out in the field.
Okay, and I guess it was kind of a bit of a surprise. It sounds like he had a lot of backing and a lot of support from different military units or former military.
Yes, yeah.
So I guess that's why they were really hoping for this appeal to go through.
I think that raised a lot of expectations, right? You had this group of, I think it was 27 retired generals and admirals who really wanted the Supreme Court to take this case and answer that question about self. When does a soldier have the right to self-defense in a situation like this, where he might be armed and doesn't really know what's going on with the other party? And you also had a situation where the Justice Department, which represented the government in this case, the Army in this case, initially declined to respond to Behenna's petition, which, again, that's not unusual. They figure, hey, we'll let the lower court ruling, speak for itself. But the Supreme Court asked the Justice Department, hey, we want to hear your arguments on this. Yeah. And that raised some expectations, too, along with, as you said, the group of retired generals.
Okay. Well, what does today's denial of appeal mean for the future of Behenna's case?
Well, that's a good question. It probably means the end of the legal part of this case. I talked to Scott Behenna, the Edmund soldier's father, today, and he said, for years we've been kind of on this two-track process, fighting the legal, side on one, and the pardon and parole side as well. And now we'll just focus on getting him out. Lieutenant Behenna is 4 years into a 15-year sentence at Fort Leavenworth. He's eligible for parole next January, and his father said that's what we're going to do. Just focus on getting him out as early as we can, and the legal process for all intents and purposes is probably done.
Yes, and Michael Behenna obviously is from Edmond, Oklahoma.
That's correct.
So that's the local tie here. All right, well, Chris, thank you so much. And you can read more on this story by Chris Castile in the Oklahoman on Tuesday, and of course on newsok.com.